leave.
He's here.
C362446, State of Nevada versus Bradley Bellisario.
Good morning.
Dan Jenkins on behalf of Mr. Bellisario, he's present out of custody.
Colleen Baharav for the state.
I have read the motions, but I am certainly never going to stop anyone from making a record.
Your Honor, in speaking with Mr. Bellisario this morning, there were additional things that he wanted me to get into. He wanted to trail the matter to the end of the calendar because some of the things involve attorney-client privilege of a sensitive nature that he doesn't want discussed, which is basically with open court.
Do we need to seal the proceedings and excuse
Yeah.
Ms. Baharav then?
Well, and that's what I was explaining to him. If it's attorney-client and if Ms. Baharav is present, then sealing is there's no point sealing the courtroom because Ms. Baharav, that like, so I was explaining that to him. He just, that was his request, that there are things of a sensitive nature that he wants to get into and he doesn't want to get into it. And it's not the court with both people, so he was asking to trail the matters.
And here's the state's problem with that. This is a motion to withdraw guilty plea, which we have the opportunity and in fact the responsibility to oppose if there is a basis to oppose. And so if we're getting into attorney-client privilege and things that the state's not going to be permitted to review, that constitutes ex parte communication, which we don't have the opportunity to object to.
No, I don't, but I think they just don't want a packed courtroom when they do it. That's how I took that, is that right?
That's correct.
But it's also not in our document, so we didn't have the opportunity to like contact counsel or do any of that. So that type of request, get into attorney-client privilege, we better serve that with an evidentiary hearing.
And I was inclined to, I was inclined to set an evidentiary hearing based on the allegations that Ms. Johnson or Torrey submitted, the allegation that she submitted a forged document. And I understand that when Judge Rouhani accepted the plea, that it seemed like she kind of got rid of some of the issues associated with whether it's Alford or guilty plea, and that documents were submitted to Mr. Grasso and they were not refiled. But just on the allegation that an attorney submitted a forged document,
Sure.
I think is severe in and of itself, and I think that we need to do an evidentiary hearing on that alone. Now, that being said, and I'm not going to stop. Look, I never stop people from making a record. Did you want to get into just the attorney-client issues with Ms. Torrey or with another lawyer?
It was basically Ms. Baharav had argued that I had said certain things about my intentions of withdrawing or my intentions of accepting the plea, but those were between me and my attorney.
Which attorney?
Goodman, Jorge, Goodman and Jorge.
Well, there were multiple counsel over,
Yes.
before I got appointed,
Yes.
there were multiple counsel, Goodman, Torrey, Grasso, and there was, I think.
Yeah, Polsky, but Goodman and Jorge were the two that were.
But as for when he started discussions of withdrawing his plea, there were some allegations in the motion as to what his motives were.
Yes.
Because the defense raised those as, he was motivated by this and basically the duress argument that because of the divorce decree, how that impacted and whether his motivations in taking the plea were motivated.
Well, so this is my concern about that. So, look, I understand the state opposed it, and I get it in the sense of, look, that was done so long before he entered the plea here, so the coercion aspect is almost belied by the record because the divorce decree was entered way before the guilty plea. But I still want to do an evidentiary hearing because of the significant allegations that have been made, and because if those are substantiated, I think that there's something to be argued, but I think that we need an opportunity for Ms. Torrey and I guess Mr. Goodman, even though there was really no reference to Mr. Goodman in the motion, but I think just to streamline it.
Well, ultimately, there were some assertions as to my client's motivations.
Sure.
And those motivations were discussed with Mr. Goodman and Ms. Porter.
Okay, so why don't we just set an evidentiary hearing for those two individuals to be named, to be witnesses in the evidentiary hearing. because their schedule is important, for sure. Why don't we set, so it's your motion, so you would have to be subpoenaing or calling Mr. Goodman and Ms. Poirier.
Okay.
I'll issue subpoenas to them, just so there's no issues.
Is Ms. Poirier still in town?
Yes.
Yeah,
Okay. Should we set this down for a status check of scheduling the evidentiary hearing? Should we just set the evidentiary hearing in hopes that it works?
Yes, that one.
Okay. All right. Want to make sure it's. How long, should we do 30 days? Should we do, I mean, we're getting into the holidays and stuff like that, so I don't know what your respective schedules are as well.
So the first week of December, I am typically out till the middle of the second week. I've been told under penalty of divorce not to schedule over our hearing.
Sure.
Thanksgiving, but, so let's not do that. And then I'm available during Thanksgiving, but most of those attorneys are gone. So either earlier in November or end of October.
End of October, early to mid-November should be fine.
And are you thinking of setting this on a special setting? Like,
Yeah, I feel like that would just be the best course. How is November 2nd at 1:30?
sounds good.
That's fine. And if there's an issue with scheduling parties, whatever, just let me know.
I should know soon. If there's a problem, we'll contact you.
Fantastic.
Thank
I'm
you.